So y'all wanted me to react to this.
Notice of being 5 minutes will serve state and the court. But it's being filed as well. This is not a file copy. Just a courtesy copy.
Okay, we'll take it up tomorrow, Mr. Steele, okay? It'll be e-filed tomorrow, so we'll take it up then. So, all right, anything further? All right, we'll see you tomorrow morning in fact, hold on. We'll see y'all tomorrow morning for 9:30, okay? All right, see you then.
But the only reason I didn't is because I had to wait for this.
That both contain assertions, bare assertions and legal conclusions which aren't sufficient for the court to grant your motion at this point in time and refer it to another judge for it to be heard. So I'm going to deny the motion at this point in time. I invite you all to look at Baptiste versus the state. Just because adverse rulings have been made doesn't mean that the court stops the trial. So I'm going to make that. I'll reduce both of the motions to recuse to an order. No, I won't grant a motion for a certificate for immediate review. And that's where we are at this point in time.
Now, I read these motions last night, so if I said something that kind of leaded to whatever happened or didn't happen, just understand I read all this stuff last night. I made some predictions, I think, but other than that, yeah, bruh, let's get into it. You know what? So we'll just give you the skinny on this. This is attorney Caleb Bumpus, the undersigned counsel, and files this motion to quash the court's order to show cause filed June 11, 2024. So basically it says on Friday, June 7, 2024, during the trial, the state immunized Kenneth Copeland and called him as a witness. Copeland refused to testify. The court placed Copeland in custody over the weekend for his refusal and adjourned until Monday. At this point, Copeland was still sworn as a witness and had not been dismissed. On June 10th at 8:30, Copeland and his lawyer, attorney Caleb Bumpus, were escorted to the court's chambers and conducted the ex parte meeting on if Copeland was going to testify or not. Those present for the substantive portion of this ex parte meeting were Glanville, Bumpus, Copeland, Miss Love, Miss Hilton, members of the court security staff and deputies, 2 investigators from the district attorney's office, and a court reporter. In the chambers, this court asked Copeland whether he was prepared to testify. Copeland announced that he planned, again, to invoke his Fifth Amendment privilege on the stand. A conversation among the parties ensued regarding Copeland's understanding of immunity, how Copeland thought he may testify if he did not invoke the Fifth, and certain facts of the case. Once Copeland learned that he could be held indefinitely by the court if he refused to testify, not just 2 years, he initially believed, Copeland decided that he would testify. Copeland added that his testimony would be a lie. That's pretty big. The meeting ended and the parties went to the courtroom. This ex parte meeting was not placed under seal. There was no protective order that directed that disclosure of these ex parte communications were prohibited. No attorney-client privilege existed clearly, as 2 prosecutors, investigators, a judge, a court reporter, and various court staffs were also all present. The court never stated, ruled, or inferred that the meeting was meant to be confidential. Oh, this is where she about to get into it and be like, so I told. That's what it sounds like. Oh, man. Further, the content of this meeting was not secret, protected, or in any way privileged information. It is unclear why any person present would have understood that the content of the meeting could not be shared with other attorneys of record in the case who were also with fellow officers of this court. So, later that same day, defense counsel attorney Brian Steele addressed this court to make a record of his due process concerns regarding the ex parte meeting. The content said meeting would not be just non-confidential, but would usually be given to the defense under Gilio and Brady, which was basically what I had read before when I said that all the judge had to do was just give him the transcripts. But the messed up part is it never says the time, so I'm going to go ahead and take my victory lap on that one. During attorney Steele's attempt to put his due process concerns on the record, this court began to focus on the identity of the source who leaked the meeting to defense counsel. The court ordered Attorney Steele to provide the name of the person who divulged the existence and content of the ex parte meeting. Attorney Steele refused. A brief hearing followed, and what initially appeared to be a classic civil contempt action, the attorney could purge himself of contempt if he provided the information to the judge, became a criminal contempt action. The court found Attorney Steele in direct criminal contempt. The court sentenced Attorney Steele to the maximum time allowed, which was 20 days to serve in Fulton County Jail. On June 11, 2024, the court entered a show cause order directing all individuals that were present for the ex parte conversation that took place in the court's chambers on the morning of June 10, 2024, specifically Copeland, his attorney, Attorney Bumpus, and all representatives of the state and court security personnel that were in attendance to show cause why one or more of them should not be held in contempt for disclosing information from the ex parte conversation to members of the defense counsel. No specific names were included in that order other than Copeland and Attorney Bumpus. That's crazy. So he already knew she did it, or he thought Woody did it. So the court seeks to hold in contempt the person that leaked the ex parte meeting to defense counsel. Thus, the contempt hearing will be about who informed defense counsel, whether to find that person guilty of criminal contempt, and if contempt is found, the appropriate punishment. The procedures that a trial court must follow to hold a person in contempt depends upon whether the acts alleged to constitute the contempt were committed in court, direct contempt, or committed out of court, indirect contempt. So basically, disclosing information from the ex parte conversation to members of the defense counsel occurred not in open court or in chambers, but at the time and location defense counsel were notified of ex parte meeting. Further direct contempt involves contemptuous conduct in presence of the court, which generally results in immediate punishment. Here, the need for punishment is clearly not immediate, as demonstrated by the show cause order being set 2 weeks out from the order. Forms of contempt are further divided into criminal and civil. Based on the nature of punishment, civil contempt is a conditional punishment intended to coerce the contender to comply with the court order. Hopkins versus Hopkins, Super 224 GA 6667 1979. So no contemptuous conduct occurred. There neither is nor was anything preventing the disclosure of this ex parte meeting to defense counsel. Disclosure did not violate a court order. There is no standing order in place or trial order that bars or any way limits defense counsel for witnesses or any other individuals present at the ex parte meeting from communicating with defense counsel for the defendants about the meeting and its contents. To the extent that this show cause order may be subject to a general demur, the order cannot pass this test, assuming as true as the allegation of disclosing information from the ex parte conversation to members of the defense counsel. Contemptuous conduct is not alleged furthermore. So basically what she's saying is that another judge has to hear this, because she basically trying to say, I ain't trying to go to jail. That's what I'm getting from this. The court must transfer this matter to another judge under procedure for indirect contempt. The court may not preside over this contempt proceeding because the court does not satisfy the following criteria. So here the alleged contemptuous conduct was, as expressed by a court, directed at least in part toward the court personally and the sacrosanct nature of its chambers. The court became involved in the controversy both by holding the ex parte meeting in the first place and by way of the fact that this court is a witness to the potentially disputed fact of whether there was any kind of order not to disclose the meeting by counsel for the defense. The Georgia Code of Judicial Conduct dictates recusal because the court's impartiality might be reasonably questioned, So, yeah, bruh, all this is just that she's saying, hey, bruh, y'all never told me I couldn't do this. So I don't get the problem because I feel like I was supposed to do this. That's all this is saying. So basically, they're trying to make sure that Glanville isn't the one to sit up here and give punishment for all of that. Because let's be fair, bruh, the way he was acting on that goddamn at the court date, I wouldn't want his ass listening to nothing either. See, look, right here, 14, that Chief Justice Glanville was referencing in a statement in a paragraph 13. So here we go right here. During the exchange from Mr. Steele on June 10, 2024, regarding the ex parte meeting, Chief Judge Glanville stated, well then, other than if you were sitting, unless you were sitting in there with the recorder or Miss Love or Miss Hilton or one of the deputies gave you that information or Miss Weaver, shot you a rough copy of the transcript, there's only one other person that's left. And if that person gave you that information and shared that information with you, she probably violated privilege because she has a client she's supposed to represent. So, I mean, that goes without saying. He's saying that Bumpus basically did that. And then he says, Chief Judge Glanville accused Attorney Bumpus of violating attorney-client privilege when speaking with Mr. Steele and made said accusation prior to any investigation, hearing, or reviewing any evidence. Chief Judge Glanville intends to preside over the June 11, 2024 order, show cause in the same above style case, and he will be the fact finder and make credibility determination concerning the parties present at the ex parte meeting. If Chief Judge Glanville was to preside over the show cause here, he will have to make credibility determinations of the court's own security personnel. Further offense saith not. I like the way that sounds. This is why he's the hood lawyer. No, I'm playing. That does not be my theme song. All right, let's just get into it. Basically, this is Brian Steele filing this, saying that on June 10th, what we already seen, a Star Chamber meeting is basically a meeting that is unfair. Mr. Copeland previously been called to testify on Friday, June 7th, basically went with the 5th. And basically, they brought, from what is being said, they brought up to Kenneth Copeland that, hey, you're going to be going to jail for a very long time. So June 10th, basically, the court was informed, based upon information and belief of the ex parte meeting of the sworn witness, Kenneth Copeland, and the prosecution occurred earlier that day, that the witness had made factual admissions that the statements were made to the witness by court and prosecutors acting in concert about the amount of time Mr. Copeland could be held in contempt. That's basically saying what the hell I just said. So, except as authorized by use of law. So this should be interesting. Uniform Superior Court Rule 4.1 and GA Code of Judicial Conduct 2.9 delineate rules governing ex parte communications. Uniform Superior Court Rule 4.1 generally prohibits ex parte. So y'all got to understand something. When they say generally, that means basically, yeah, you could do it, but that don't mean that it can't be done. So I like how a lot of these lawyers will say all of this crap and then genuinely mislead y'all and not put that stuff up. There was a lawyer that I was watching yesterday, and I'm like, why are you skipping these words, sir? I watched a couple of lawyers on this. There were some good ones, but there were some terrible ones because there is a brotherhood that exists. So the court violated USC R41 Georgia Code of Judicial Conduct 2.9. The court has joined the prosecutor's team in bias against Mr. Williams and favorable to the prosecutors objectively demonstrated on June 10th. But here's the thing, right? And I'll say it. Are we sure? Because I don't know if that's coercion or not. The trial rejected undersigned counsel's substantive requests for information about the unlawful ex parte meeting, and the court denied undersigned counsel's motion for mistrial. Instead, the court stunningly demanded to know how undersigned counsel came into possession of the information about the ex parte meeting. The prosecutors stunningly sat mute and permitted this injustice to occur, and for the court to attempt to intimidate undersigned counsel. Later, Love, a lawyer currently employed with Fulton County District Attorney's Office, argued that the ex parte hearing with witness Copeland was ethical, just, and proper. The other prosecutor still remained mute. He's talking about Ms. Hilton. So basically, he's saying that the court issued a written order of contempt. He's going through basically what happened. See, a lot of people, they want me to read all of this, but for what? Basically, motion to disqualify recused Judge Glanville is timely filed as Uniform Superior Court Room 25.1 mandates that the time for fitting a motion to recuse should not be later than 5 days after the offense first learned of the grounds for disqualification. The Honorable Supreme Court of Georgia has taught that a motion to recuse is timely filed. So the record reviews numerous instances during the trial in which the judge's behavior appears to have been biased against Mr. Williams. So this is where he's supposed to basically say that this happened. Because all this crap right here that I just passed by, Exhibit B, Jordan Fain, however, represents more than the mere fiction between zealous counsel and a diligent jurist. The judge's conduct, as discussed above and herein, created the impression that he harbored an inclination to be biased against Mr. Williams and his counsel and partial toward the prosecution. And he just basically finding ways to call him biased. So, importantly, we just gonna scroll down, bro, because a lot of this stuff that they're saying is just word salad. It's being verbose for no reason for us to even care about. Now, in the courts, this all matters, but to us, this crap don't matter. So we'll just go down. During the proceedings in the above style case on the afternoon of June 10th, basically tell them what Steele did. So we're not going to read all of that crap because it's unnecessary. Saying Keith Adams joined in. This is interesting. Mr. Copeland, a witness who had been called by the state and sworn on Friday, June 7, 2024, and invoked his Fifth Amendment and was held in civil contempt by this court, was brought to the Fulton County Courthouse on Monday morning, June 10, 2024, unbeknownst to faint Mr. Williams or anyone else on the defense side of this case. This court met in its chambers with Mr. Copeland and counsel, Lawyer Love and or Lawyer Hilton, at times court reporter Weaver, as well as sheriff deputies and other persons. Deputies may have been instructed to turn off their body cameras. That's insane. There was and is nothing privileged under law about this improper ex parte meeting. The court and others met with Mr. Copeland for a lengthy period of time. The total ex parte meeting lasted for more than 1 hour, approximately 2 hours, with the above named people at the meeting at all various times. Mr. Copeland continued to make known his assertion that he would not testify, even in the face of being held in contempt, in order to testify under use immunity. This court and a lawyer for the Fulton County District Attorney's Office, Love and or Hilton, ignored Mr. Copeland's decision and continued to declare to Mr. Copeland that he would be held in custody until he testifies, or alternatively, if he persists in refusing to testify, he would be held in custody not until Mr. Williams' current trial resolves, no, but until all 26 indicted persons' cases are resolved, which is longer. The court was a participant and was present during these admission threats to Mr. Copeland. This is a witness intimidation coercion. But see, and that's where we got to sit back and judge for ourselves. So I ask you, was that really coercion? Because basically, all that's really saying is, hey, Mr. Copeland, you think you're getting out of here in 2 years, bro? Nah, you're going to be here until the whole entire thing is done. So, So basically, this is the craziest part, right? The court, lawyers Hilton, Love are now witnesses to the case and will be called by Mr. Williams and possibly other accused so the jury can determine demeanor and credibility of what occurred at this in-chamber meeting. Please note that the witness list is hereby amended by this joint affidavit to include the court, lawyers Love and Hilton, and all other relevant material persons that have information to share with the jury regarding the conduct, words, and actions at this ex parte communication. This court provided Mr. Copeland with a written copy of the statute on crimes of perjury as well as false swearing. There is no subtle gesture, and one that helped the prosecution team to obtain their motion for Mr. Copeland to change his mind and testify. Lawyer Love made representations to the court in front of Mr. Copeland and his counsel, sheriff's deputies, court reporter, and others that Jonathan Melnick, Esquire counsel for Mr. Copeland, committed misconduct during his representation of Mr. Copeland, was not representing the interests of Mr. Copeland. These are knowing misrepresentations by Lawyer Love to this court, which Lawyer Love continues to do. He just had to put that in there, bro. That's petty as hell, but I function with it. I function with it highly. Let me read that. Hey, that's petty. Lawyer Love made representations to this court in front of Mr. Copeland and his counsel, sheriff's deputies, the court reporter, and others that Jonathan Melnick, Esquire counsel for Mr. Copeland, committed misconduct during his representation of Mr. Copeland and was not representing the interests of Mr. Copeland. These are knowing misrepresentations by Lawyer Love to this court, which Lawyer Love continues to do, which biases this court in favor of the state and against the accused, their lawyers, and other members of the bar. Further, the court permitting Lawyer Love to speak ill of Mr. Copeland's counsel in front of Mr. Copeland adds to the coercion and witness intimidation. But if it did, then why the hell didn't Woody fire him years ago? This ex parte discussion violated Mr. Williams' constitutional right pursuant to Article 1, Section 1, Paragraph, 8? No, that's 7, sorry. The Georgia Constitution to be present at every material stage of this trial. So we're not finna keep on reading the same crap over and over and over and over again. But basically, this is to certify that I this day served a copy of the within and foregoing motion to disqualify, recuse Judge Glanville from all further dealings in the above referenced case and motion for mistrial, which was goaded by the improper conduct committed in the concert by the court and prosecution. So if y'all remember, man, Brian Steele is full of threats that he doesn't see through. Y'all got to remember, Brian Steele been threatening to go after Miss Love, report her to the bar. Brian Steele been threatening to try to get the judge recused and all that. Remember this?
17th, 2013, I'm recording. Mr. Bean tells that to Detective Quinn. How is that far-fetched? Why would he ever say that? I lied to the other detective. Why would he ever say that? I mean, logic has to come into this courtroom at times. But you stop me from doing it, but you allow another lawyer make up that I'm stopping and starting a recording. And he says, well, I don't recall, I don't remember anything.
Here's the thing, that's why probably Miss Love asked me to put it under seal for the time being. But I mean, I'm not saying anything, but if true, that's a pretty serious accusation.
If true, I'll die right now. How about that, Judge Glanville?
Your Honor, I object to this.
I don't care about her objection. I'm speaking with the
Your
court.
Honor, I object.
I'm
I'd like to
speaking
level
with
an
the court.
objection.
Okay.
I'm speaking
Let
with
him
the
finish,
court.
and then you can state your.
My point is, if you don't see what's going on, it's because you're not viewing it out of the lens
But
of a juror.
Mr. Steele, I can't do that. I have to be the referee. So the jury decides those particular issues of believability and credibility. Now, I'm not getting into the throes of war between you and the state. That's your business, and that is
I have
certainly
nothing to do with a throw war.
No, but I mean, it's your ability as an advocate. I told you before, that's your ability as an advocate. All right.
What I'm saying is, you said in front of this jury, I was unprofessional. I am not unprofessional. You were wrong.
I think at that particular point in time, given the totality of what happened, that's what the court's assessment was. Sir, I am.
But it was wrong.
It's a snippet in time. Mr. Steele, you're a very good attorney, but I'm a professional jurist, and you may not like some of the rulings that I make, and you may not like the way that the trial is going at a particular point in time. That's for all advocates. Ms. Love and her colleagues, I've told them the same thing. But I think that, my job as the referee is to give you a fair trial. And that's what I'm going to do.
Well, I hope that's true. But you just told the jury I'm unprepared. And I am prepared. I don't understand why you would say that.
Both of you, and I'll level this against the state. Both of you, that's being unprepared, because that I have to then listen to this to rule on it.
I understand, but I'm the only one that the jurors here, the court, take ire with. Ever. Without an apology, without.
Oh, I think I've taken Miss Love and Miss Hilton and her colleagues to task many times.
No, I've heard you yell.
I've taken them to task as well.
I've heard you say to her, "Stop interrupting me." Answer my
that's
questions."
taking them to task.
The jurors never heard that, ever. So, I ask for a continuing recusal motion. And I know it's not in writing, but I assume that you're ruling on it right now. That's what you're saying.
Well, when you got to put it in writing, but I mean, I'll rule on it at this point in time. I'm going to deny the motion, but you need to put it in writing if that's what you wish to do, and I'll appropriately.
I'm also asking for a mistrial based upon your statements. I think I made that clear, but I'm asking for a mistrial.
Okay, now, Ms. Love.
I don't think it's a fair forum for Mr. Williams.
Okay.
And I don't want to ask for a mistrial, but I have no choice when the court is saying what it said, and I'm not going to repeat it in front of a jury. That's hurtful. And I'm not saying me. I mean, regardless of what I think of it, it's hurtful to Mr. Williams getting a fair trial.
All right, Mr. Steele, in terms of what I've told you all already, we're still going through the, I've told you all, both sides I've told you. So this just delays the trial. I mean, where I've got to rule upon other things.
Well, I made this motion whenever I made it, and I raised it, and you said we'll get to it.
Yeah, but it's timing. I mean, did you raise it when we first got in here this afternoon? Did you raise it yesterday? Did you raise it kind of so I could kind of take it at that point in time? None of you did.
If I would have been told that there were going to be 3 additional jail calls, I could have raised it. The 2 others are already in. I didn't object.
All right.
Now, there are a bunch of new channels reacting to this because it's catching fire. But we know because we've been here. That's what's going on, bro. Unfortunately, this is all theatricality. Brian Steele is smart. What Brian Steele basically did was essentially set it up a play that he can get a mistrial, and if he doesn't get a mistrial, then goddamn, Brian Steele will have somehow entered the mind of the judge and make the judge think twice before he goes about his actions. Well, Ceddy Nash, what the hell are you talking about? Go about his actions. Nah, bro, Brian Steele knows what he's doing. Brian Steele is a chess player. And I'm not saying this because I like Brian Steele or I dislike Brian Steele. This is one of the only channels who remain objective. No disrespect to all the lawyers, but y'all in a damn lawyer brotherhood / sisterhood. So if I'm of the belief that y'all are, because what lawyers have y'all heard come out and really praise the judge all the way? It's very small. On top of that, we hear lawyers complain about judges all the time. Are we new to this? No. So you get some judges who have a bias and some judges who don't have a bias. Unfortunately, Brian Steele drew the short end of the stick. Or did he? I want y'all to understand it in a way that's simple as hell. If I say, you treat me bad, 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 you're going to start to ask yourself, well, how do I treat you good? I'm going to keep it authentic with y'all, and we'll probably come back and rewind this statement and be like, damn, Ceddy Nash is right. If I'm to believe that the lawyers have a brotherhood, I'm 100% going to believe that the damn judges, the justices, the judges have a brotherhood. Y'all got to remember, it has to go through 2 judges. So 2 judges had to say that Glanville is wrong. And I find it funny how y'all act like y'all give a damn about recusals, but y'all didn't give a damn about recusal for the young Dolph murder. Hell, if we're to be understood, and even though it's Tennessee, it's not Georgia, even though they connected at the hip bone a little bit, bruh, do y'all know that it took Judge Coffey 3 months to get recused off the case? So what y'all think gonna happen for Young Thug? The wheels of justice and appeals and all of that, bruh, we're not finna do all that. That's why the judge's like, I'm not, emergency what? And that's the part where I need people to understand. You attract more flies with honey than you do vinegar. If Brian Steele would have just swallowed his goddamn ego and his pride without all the yelling and stuff like that, if he would have been more on the judge's side to get the judge to come to his side, meaning like this, Brian's still doing all that yelling instead of Brian still saying, Judge, I understand your point, but I disagree, so that we have no more hiccups in the case. Is it possible that we can get this expedited to the court cases so that we don't have anything that's going, anything that's being said about us, so that we're having a fair trial instead of, no, let me finish, let me talk, let me finish, I'm like, still, bro, it's not working. Y'all show me the one time where Brian Steele got up there complaining and trying to plead his case and it worked. Because it hasn't. That's why when Keith Adam goes up there and he speaks, he's not yelling. He's not. He's just concise, short, to the point. Now, to what happened today. Judge, I ain't gonna hold you, bro. These motions and all this should have been done way before. And this is why the YFN case was so goddamn important. Because what ended up happening is they did all the motions and did all of this stuff way before the damn trial even started. And then when the state tried to introduce some new stuff, the judge like, no, we're not doing that. You should already had your case. That's how YFN and them beat it. They didn't beat it because Drew Finland was that damn good. Drew Finland is good. He ain't that goddamn good. They did it because they had a good judge who was like, we're not adding none of this stuff. Glanville added everything. And I'm telling y'all, bro, Glanville's accolades are better for the judges than goddamn Brian Steele's. Who's a veteran for the United States Army? That would be Glanville. Who's doing goddamn military court? That would be Glanville. Who's the one who's been the judge? That would be Glanville. So I need y'all to understand something. Get out of your feelings. Have your affinity, meaning have your likes, but sit back and just go, this is a judge. He is the referee. Who knows more about the game? Would it be the coach or would it be the referee? Would it be the player or would it be the referee? Not who understands how to play it better. Who understands how to enforce the rules. And that is what the judge is, and he told y'all that. Now, there is not a lawyer worth they salt who will go against what I'm about to say because y'all can't. Y'all keep giving yourself caveats. None of y'all definitively can say the judge is all the way wrong and he should be disbarred and all that stuff. None of y'all are saying that with any truth in what y'all saying. Because at the end of the day, majority of these laws have little workarounds where this judge is going to be right. He ain't going nowhere. And a year from now, when it starts dwindling down and they start getting ready to make their closing arguments, y'all gonna be like, damn, Ceddy Nash, we thought. So I get it, the theatricality of it all. Hey, the judge is finished. He's done and all that stuff. No, the best thing that Brian Steele can do is get a mistrial. And get a mistrial on the error of the judge in the DA's office, because if he is able to do that, then you can't turn around and then retry them. They would have to find new evidence. So Brian Steele's whole major thing is, let me get a retrial, 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 let me get a retrial. And so one day the judge might just say, yeah. But what Brian Steele doesn't know is he ain't take the time to understand this goddamn judge. This judge will rather it go to appeals, would rather Thug sit in the penitentiary if he get found guilty of everything, and then 4 or 5 years later when it gets retried on an appeal, he would rather that than send Young Thug out of there. And the reason why I know that, check it out in the comments. I'll catch you on the next one. We got a crazy video that's going to drop tomorrow. And yeah, we finna go after the judge, because I don't want y'all to watch this video and be like, well, Sonny, that's on the judge's side. Nah, I'm about to kick the judge square off in his ass. Let's do it.